The following program was recorded on an earlier date for presentation at this time.
Hello, welcome to the History of Now. On Friday, June 26, 2015, the Supreme Court issued its ruling in the case of Obergefell v. Hodges, holding that the recognition and provision for same-sex marriage is a fundamental right guaranteed by the 14th Amendment to the United States Constitution. Many commentators, including people in this class, have predicted that this landmark decision is one for the history books, and that we'll be studying this in history classrooms of the future. And so our exploration of the history behind this present moment could go in many different directions. We might see protection of same-sex marriage as a pivotal moment in the history of the now 50-year-old gay rights movement. Or we could examine it in the larger story of the Cultural Revolution of the 1950s and 60s, which profoundly reshaped American society. On the other hand, we could think about this in the much broader context of the history of marriage in the United States and the shifting evolution of societal norms around the institution. But here I want to focus on the role of the Supreme Court, and more precisely the constitutional history of the court's interpretation of the 14th Amendment. Now, here's just a very brief background to the case Obergefell v. Hodges. In June 2013, James Obergefell and John Arthur, a same-sex couple of 21 years, were married in Maryland. At that point, same-sex marriage was recognized in Maryland as well as dozens of other states, but not in the couple's state of residence, Ohio. Obergefell and Arthur's timing for this case was based on two facts. First, John Arthur was terminally ill with Lou Gehrig's disease, and they wanted to ensure that Obergefell would be legally recognized as his surviving spouse. And two, the Supreme Court had ruled that June, in the case of the United States v. Windsor, that restricting the federal interpretation of the word marriage or spouse to apply only to heterosexual unions violated the Due Process Clause of the Fifth Amendment to the Constitution. Now, in taking up this case, the Supreme Court had one major question to answer. Does the Constitution prohibit states from distinguishing between gay and straight couples for the purpose of marriage? That is, can states make their own rules about gender requirements of marriage, or is marriage a fundamental right that all citizens have, regardless of sexual orientation? This question required that the court justices interpret and make arguments about the meaning of the Constitution, specifically the 14th Amendment. And this process, in which the court examines a law to decide whether or not it's constitutional, is called judicial review. It involves interpreting the entire text of the Constitution, including the amendments, but the 14th Amendment is the single most litigated part of the Constitution because it is the core of American civil rights, and because its wording is both all-encompassing and very broad. So let's take a look at the 14th Amendment. This is the major section, Section 1. First of all, it declares that all persons born or naturalized in the United States are citizens of the United States and the state in which they reside. This transformed the concept of American identity, because before this, individual states made the laws of citizenship. Second, and then this is the sort of key piece, is that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So you see essentially there, if you are a citizen of the United States, you are entitled to all of the privileges and immunities of citizens of the United States. And these cannot be violated without a due process. Everyone has equal protection under the law. That's the 14th Amendment. Now, what can history tell us about the relationship between the 14th Amendment and the Supreme Court? Pretty much everything. To start, the concept of judicial review itself is a historical development. In 1789, when the Constitution became the law of the land, it was not at all clear that the Supreme Court had this power. In fact, during the raucous partisan battles of the 1790s, no less than Thomas Jefferson and James Madison put forth the proposition that it was state legislatures, not the court, that had the right to deem a federal law unconstitutional. Later, during Andrew Jackson's presidency, South Carolina resurrected that concept, claiming the right of states to nullify federal laws. So that is, the legislatures of individual states having the power to decide the constitutionality of laws. Now, the concept of judicial review had a long history in English law, but it was the landmark 1803 case, Marbury v. Madison, in which the Supreme Court asserted this power for itself. Leaving aside the details of this particular case, what Marbury v. Madison did was help sharpen the lines of power between the three branches of government. Over time, the ability to decide questions of constitutionality became the job of the Supreme Court, the judicial branch, as opposed to the legislative or executive branches. And this has enshrined the concept of judicial review as something falling under the distribution of labor for the Supreme Court in the three branches of government. Now, the Supreme Court has exercised this power in major and decisive ways. For example, its historic and infamous 1857 decision to the case Dred Scott v. Sanford was one of the key events leading to the American Civil War. In this case, a slave named Dred Scott sued for freedom on the basis of the fact that his owner had taken him into federal territory where slavery was illegal, and as a result, he argued, of his residence there, he had become free. In a 7-2 decision written by Chief Justice Roger B. Taney, the Supreme Court ruled that Dred Scott had not attained freedom because the federal government had no power to restrict slavery in federal territory in the first place. Federal limits on the expansion of slavery, the court essentially decided, were unconstitutional. Furthermore, in a notorious second ruling, the court decided that Dred Scott had no standing in federal court anyway because he was black. According to this Supreme Court, African Americans, whether they were enslaved or free, were not and could not become American citizens and therefore had no civil rights. The Taney Court's ruling here would, of course, become moot at the end of the Civil War with the passage of the 13th Amendment, which outlawed slavery in the United States. Then, during the contentious process of Reconstruction, when Southern states resisted the terms of reunification laid down by a Republican-dominated Congress, including laws designed to guarantee certain rights for the population of former slaves, Congress enacted the 14th Amendment, making civil rights fundamental to all American citizens, regardless of race. The final Reconstruction Amendment, the 15th Amendment, did the same specifically for the right to vote. Now, within no time at all, there were challenges to the 14th Amendment's provisions on due process and equal protection under the law. These challenges were taken up by the Supreme Court under the principle of judicial review. In 1872, during Reconstruction, major mob violence erupted in Louisiana over the election of the state's governor. The violence, perpetrated by Southern Democrats, was directed at black men and women as well as white Southerners who were attempting to vote for the Republican Party. In Colfax County, Louisiana, at least 105 black people and 3 white people were massacred at the parish courthouse. A number of the perpetrators were later charged with violating the victims' basic rights of due process and equal protection under the 14th Amendment. When challenged, this went to the Supreme Court in the case of the United States v. Cruikshank in 1875. The basic question the Supreme Court had to address was, did the murderers of 105 black people and 3 white people violate their victims' rights to due process and equal protection? The decision of the court, no. In its 1876 decision, the court ruled that the 14th Amendment does not protect Americans from violations perpetrated by other individuals, only by states. This was a narrow reading of the 14th Amendment that severely limited the concept of protection in the Equal Protection Clause. In reading the Constitution this way, the court had excluded from consideration the very history behind the 14th Amendment as designed to protect black Americans from arbitrary rule and violence in southern states. 20 years later, the core historical rationale for the 14th Amendment was put to the test in the case of Plessy versus Ferguson. In the intervening 2 decades, the court's narrow interpretation of the Due Process and Equal Protection Clauses had allowed for the establishment of institutionalized racism throughout the South in the form of Jim Crow, laws that enforced racial segregation in all public facilities, schools, trains, libraries, drinking fountains, on and on and on. One of the hundreds of such laws was Louisiana's Separate Car Act in 1890, which mandated whites-only and colored passenger cars on the East Louisiana Railroad. To challenge the constitutionality of segregation laws, a group of black, Creole, and white Americans in New Orleans formed the Committee of Citizens and recruited a man named Homer Plessy, who was of mixed race, to volunteer to be the main figure in a test case. On June 7th, 1892, Plessy bought a first-class train ticket and boarded the whites-only car in New Orleans. As planned, when he was discovered, the train was stopped and he was arrested. Over the next 4 years, the case moved through the court system, with both opponents and supporters of segregation pushing it toward the Supreme Court for a ruling. Finally, in 1896, Plessy versus Ferguson, the court heard arguments rooted in interpretation of the 14th Amendment. The basic question before the court: does enforced segregation based on race violate the civil rights of Americans guaranteed by the 14th Amendment? The ruling: no. In a 7-1 decision with the majority opinion written by Justice Henry Billings Brown, the Supreme Court of the United States ruled that forced separation of races is constitutional, so long as the facilities designed for each group are equal. Articulating a principle that would come to be known as separate but equal, the court declared that segregation was legal and constitutional because nothing about it, quote, stamps the colored race with a badge of inferiority. If black Americans feel inferior because of segregation, the court said, it's not because of the laws themselves, but because they choose to put that construction upon it. As a result of this decision, institutionalized racism and white supremacy would be considered constitutional for the next 60-plus years. Now here's the fascinating thing about history. When the significant constitutional challenge to Jim Crow again reached the Supreme Court with 1954's Brown versus Board of Education, this time the Supreme Court under Chief Justice Chip Earl Warren would come to precisely the opposite ruling about segregation. The NAACP put together a major case against segregated schools, and its chief counsel, Thurgood Marshall, argued it before the Supreme Court. The court faced the same exact question as it had nearly 60 years earlier in Plessy versus Ferguson. Does enforced segregation based on race violate the civil rights of Americans guaranteed by the 14th Amendment? And where the last court had, by 7-1 decision, said no, this time by unanimous decision, the court said yes. Segregation of white and colored children in public schools has a detrimental effect upon the colored children. Separate educational facilities are inherently unequal. Thus, the court ruled the doctrine of separate but equal is a violation of the 14th Amendment and unconstitutional. Now, what I want you to think about is the role of history in this process of judicial review.
So this history of now assignment is on the Supreme Court and its interpretations of the 14th Amendment. Your key question is, how has the Supreme Court's interpretation of the 14th Amendment's provisions on civil rights changed over time? And I also want you to think about why these have changed. So to do this for this report, use the internet or the library or any reference materials you have to discover a past Supreme Court case centered on the 14th Amendment. The only caveat here is that the case cannot be one that I mentioned in this video. None of the Supreme Court cases that I mentioned in this video can be used for your report. Do a little research on this and write a 1 to 2 page report explaining the case and the court's interpretation. I also want you to think about the question, based on your knowledge of historical context, why do you think the court ruled the way it did at that particular time? Upload this 2-page report to Canvas by 11:59 p.m. on Sunday, April 22nd to earn up to 25 points, and talk about it on the discussion boards for more points.